Please be seated.
We'll hear argument in 23-1039 in re East Texas Medical Center.
May it please the court, Mr. Walsh will present argument for the relator. Relators have reserved 5 minutes for rebuttal.
May it please the court, I'm here. Amicus counsel is sitting with me at the table just to make sure I don't screw something up about non-subscriber law, and our trial team's behind the bar. There are two reasons that the decision from the Court of Appeals is wrong or incorrect in my view, and that's the first is that to be excluded under Chapter 33, the claim or the action must be for benefits under the workers' compensation laws. And I don't think it's for benefits because they seek damages, not the specified benefits in the statute. And the second reason is that it's not under the workers' compensation law because all the workers' compensation law says is it's a negligence claim. It provides no details or fleshing out how to have a negligence claim, what it's about. And that's what we looked at the common law. So it's really a common law claim that has some parts of it altered by the workers' comp law, but it's not under the workers' comp law. To dive, I also want to say, I want to answer your questions too, so while I have some prepared remarks, please feel free to fire away. Starting with, it's not benefits. Section 4010115 defines benefits under the workers' comp law as medical benefits, income benefits, death benefits, or burial benefits, at least two of which are inapplicable because Ms. Dunn is alive. As for medical benefits and income benefits, the statute creates a regimented scheme about how to calculate and how to apply for and get either income benefits or how to apply or get medical benefits under the statute. While plaintiff seeks loss of past and future earnings and earning capacity and medical expenses, she doesn't have any limitations that would be existing under the workers' compensation laws. In addition, she seeks other damages, pain and mental anguish, physical impairment, physical disfigurement, which would not be benefits under the statute. The second part of the statute that's relevant is the statute itself makes a distinguishes between the term damages and benefits because Section 407-001A allows for a claimant who receives benefits under the statute to sue third parties for damages. So the statute itself has made distinguishing features between the words damages and benefits.
So there is a difference. I understand that. But in the Civil Practice and Remedies Code applicability section that you're referring to, it says to collect workers' compensation benefits under the workers' compensation laws of this state. Is reliance on the comp bar, at least as far as contributory negligence goes, isn't that an action to collect benefits under the law, workers' compensation laws, even though it's ultimately the benefit that you get is the benefit of gaining some advantages in a suit for damages?
Well, except for she's not seeking benefits under the workers' compensation law. She's seeking damages, right, against a non-subscriber. And that's why I think it goes beyond what
But she's taking advantages of certain benefits that the law provides you. And you're saying, but we should read benefits as sort of a term of art in terms of what you receive in terms of compensation.
Well, correct, because the workers' comp statute defines benefits. And so that's why I have to start with, if we're looking at what the term benefits under the workers' compensation law means in 33002, then you need to go look at the definition of benefits under the workers' compensation law, and that is medical benefits, income benefits, burial benefits, or death benefits.
Why do you think, I mean, we have to look at this with the background of the legislature is saying don't apportion those benefits, right? Because Chapter 33 doesn't apply, so you're not carving up benefits under the workers' compensation law, right, because somebody else may have been negligent. Because the whole point of workers' compensation law, right, is it doesn't matter who's at fault, you get these benefits, right? That's the whole idea. And so with that as a backdrop of understanding why the legislature is saying Chapter 33 doesn't apply, do you think that supports your reading of benefits or a broader reading of benefits?
I think that supports my reading of benefits because in the no-fault scheme, we would never look at trying to apportion liability. And in fact, the section I was talking about, 40701, allows them to sue third parties that have caused harm, and the Workers' Compensation Act allows the employer or the insurer to have a subrogation claim of that lawsuit if they paid benefits. So the idea of paying the employee, that's part of the bargain. you get these certain benefits, but we don't determine fault. If you have a course and scope event, you get paid the benefits for your injury under the regimented rules of the statute. That's completely different than what existed at common law, which was a suit for damages, for negligence, or whatever other theories you had against the employer. And that the workers' comp was a compromise to prevent the apportionment of those sorts of things. But if we look at the 406-033, which is the limitation of damages that Justice Bland was talking about, that's all about limiting your claim that you might have against the employee or the fellow employee, people that the employer should in theory be controlling as the work process goes on, right? And so that's why there's not an assumption of risk or contributory negligence against the employee, right? Because that would be apportionment of liability. But it says nothing about third parties. And how would you deal with third parties, even in this very lawsuit, right? It started out as a claim against who we've named now as responsible third parties, Mr. Wolverton and his employer ETMC EMS. That would have gone to the jury, are they saying that if we're 1% at fault, we pay whatever the jury finds as damages, and then if Wolverton and EMS are 99% fault, they pay 99%, and voila, the plaintiff gets a double recovery? I don't think under the one satisfaction rule, the plaintiff should be allowed to get a double recovery, which is why this is not apportioning benefits. This is, or the statute is not limiting apportionment of theories of liability against other parties, right? So this is a third party, not the employee, not the fellow employee that is prohibited by the statute. This is somebody unrelated. And if we look at the court's cases, whether you look at King 2 or Austin versus Kroger, you're dealing with the situation of talking about proportionate responsibility or comparative fault as applied to the employee, which is very clearly right there in the statute saying you can't do that. And that's not what we're trying to do. We're not trying to blame Ms. Dunn for causing this event. We're blaming other third parties to the lawsuit, which is what the whole responsible third party statute's about, and allowing us to pay our fair share for whatever is our fault and have them be apportioned whatever is their fair share of fault. And so we're not overpaying their percentage of liability. And that goes back to if you think about how the non-subscriber situation works now, it's not 1% and you're strictly liable for everything everybody else did in the world. That wouldn't be a fair system. And you would be making the employer have a duty to control all these people that he doesn't control, all third-party drivers for car accidents, all people in your workplace that are doing harmful events that you don't control. You now have a duty to control them, expanding duty. And then how does the insurance industry that's developed for non-subscribers, they're adjusting risk looking at you as the employer and what you do and adjusting risk for that and setting your premium. But now they're going to have to insure against all other third-party conduct. That would shake that market up dramatically if this precedent is allowed to stand. That's the problem with this is it's a dramatic upheaval in the system by not letting us blame who's really at fault in this lawsuit. And if you look at the plaintiff's theory of the case, it's Wolverton and EMS were negligent, and ETMC Athens was somehow supposed to step in and prevent their negligence or train them or something, but they're not even being blamed for their own conduct anymore. And that's all we're trying to do is have a jury assess what is their fault versus what is our fault and causing her injuries.
This arises here in terms of the responsible third-party designation because the EMT and his employer were dismissed because they didn't file an expert report. And so they're out of the case, and so that puts you in the position of wanting to say, well, they're a responsible third party. If they had filed the expert report and you went to trial with them as co-defendants, how, in your view, would this play out in terms of the potential liability your client would have?
It would have to play out in a similar fashion with a jury assessing their responsibility and our responsibility. And as long as we're not assessing Ms. Dunn's responsibility in causing the accident,
right.
We should get
You would not be able to get the benefit of any contributory negligence by the plaintiff, but in your view, you would get the benefit of any negligence that was approximate cause by the co-defendants.
Correct.
And do you think it's the same if they had filed the expert report and not been dismissed, but settled before you went to verdict? Would you be in the same position that you would get the benefit of the settlement credit from the two of them?
and submit them as a settling party to the jury. I think you would have to, otherwise you're resulting in this potential windfall of where we're 1% at fault, they're 99% at fault, we're paying 100%.
But you still would not get the benefit of any negligence on the part of the plaintiff.
Correct. Let me say it this way. So let's say the plaintiff is 20% at fault and then we are 40% at fault and the co-defendant is, or the former co-defendants are 40% at fault. They would get the benefit of the 20% on her. We would not, so we would pay 40% and get no benefit of that, and we could only look to them to pay their 40%, and there would be this missing 20% as to us. But they get the benefit of our 40% and the 20%, right? And
So in your view, any of the three scenarios, tried, settled, or dismissed, the result would be the same.
correct.
But how would it work if it was tried and the jury, let's say, put 10% on the plaintiff? That leaves 90, so divided by 30% on each of the defendants. The other two defendants would get the benefit of her 10%, but you would not.
Correct. So when we go to figure out who pays what, they get to deduct 10%, say it's 100, say I just pick out 100,000. They
Right.
get to deduct 10,000 off the top and then figure out their percentages. We don't get to deduct 10% or $10,000 from the top. And we just have to pay whatever 30% times that number is. And in fact, I think the reality is it ends up with, as you would try it in that fashion, we would end up absorbing her liability as, kind of as her employer, so to speak.
Would the applicability provision matter if there weren't the changes to the Civil Practice and Remedies Code in 2005 that permitted this robust responsible third-party practice? So in Keach, I think we said we don't need to reach the question of whether these are benefits under the code, because under the code you don't get the benefit of contributory negligence, and that's as far as we need to go. And we didn't have the third-party practice back then.
Well, in 95, 33 had the ability for the defendant to sue a third-party practice was built in there. It had the provision to extend limitations by 60 days, but it didn't have this random naming of people without them being brought into the lawsuit.
Right, responsible third-party practice.
Yeah. And so I would be making the same argument to the 95 statute that I'm making here if I had sued Wolverton and EMS to bring them into the lawsuit and they said, I can't do that, right? Because I'd be making the very same argument of they're a third party, not the employee or fellow employee, and so they're not within the provision of 406-033. Oh, yeah. Also, a couple, if you think about rewording the statute, had the legislature intended to exclude non-subscriber cases from the Chapter 33 provision, it could have said all work-related injuries, or it could have said non-subscriber cases and workers' comp cases, but it chose this language of people or actions to collect benefits under the workers' compensation laws, which I don't think that's what a non-subscriber case is. I think of that as a common law negligence case because the statute doesn't provide us any grounding of what are the duties the employer owes, how does the employer breach those duties. We have to look to the common law to figure that all out.
Why would they also include actions, the gross negligence wrongful death actions?
That might be the legislature's compromise over, or the thought of compromise over how to deal with someone has now died and it's the employer's potential fault. And so we're looking at that. But I don't know why, but that's existed even before the 95 statute. So that existed before there was third-party practice built into Chapter 33. So that might have been just a carryover from the olden days of looking at it as contributory negligence as opposed to these other proportionate responsibility or comparative fault schemes. And nobody thought of it, or it might be death is a little bit of a different situation, and so we want to get more benefits to the decedent's family if it's a work-related injury.
And then, you're almost out of time, what would happen if your client was not a non-subscriber In other words, the workers' comp exclusive scheme did apply to any recovery from you, but she also had a claim against the EMT and the EMT's employer. Would they be tried separately, or yours would be resolved separately and then it'd be a settlement credit for the others, or how would that work?
No, mine would be an administrative, primarily an
Right.
administrative proceeding,
Right.
and then resolution with payment of benefits. And then as it comes to the third parties in this case, they would be tried, and they don't get what's the rule where,
Oh, the collateral source.
collateral source, thank you. They then get collateral sourced out. But I would also, as the workers' comp insurer, would have a subrogation interest in that lawsuit to get the
Yes.
benefits back that they paid. But it's a totally different scheme if I'm in workers' comp.
Right.
Any further questions? Thank you, counsel. We'll hear from the real party.
May it please the court, Ms. Hobbs will present argument for the real party in interest.
May it please the court. I would like to backtrack a little bit and go to a procedural issue that prevents the court from reaching the broader issue that has been argued this morning by the realtors. And that is that the trial court did not abuse its discretion in striking realtors' RTP designation because relators provided no evidence to support the responsibility of Wolverton and ETMC EMS. When a healthcare provider is designated as a responsible third party, this court, going back as far as Palacios, has said you need a qualified expert, and they have minimal things. They do not need to marshal their evidence. That report does not need to be detailed, but you at least have to show that there was what the standard of care was and that there was a breach of the standard of care. Duty, breach, standard of care. And what the relators rely on here is the designation and report of Timothy Hawkins, who is Ms. Dunn's expert witness. This is not an expert witness from the defendants. And her.
Does that matter? I mean, if the report says
It
what it
doesn't,
says,
except for
but-
to say that it's insufficient to get them on the RTP line. So the designation and report, which is the only expert report they're relying on, is MR 413 to 424. That encompasses 2 volumes. I think it's 3 and 4. It's kind of like the report is kind of split up between 2 volumes. And this is, Mr. Hawkins is a non-physician. He's an administrator, and he does not at all opine about the standard of care for EMS Wolverton in operating the structure at issue in this case.
Let me ask about, before you get into the details of the expert and the testimony, question about whether Chapter 74 applies, because ETMC is not a claimant, and it only requires claimants, right?
For sure, but in order to move to strike a RTP designation, when you move to strike, you have to show that there's no evidence. And so if you do not have an expert witness that says what is the standard of care for an EMS in the use of the stretcher in a hospital setting, under the circumstances in which Wolverton was using the stretcher, that's no evidence. So it doesn't matter
it's
whether.
no evidence. It's the standards being imposed by the responsible third party statute, not by Chapter 74.
Exactly. Thank you, Justice Busby. Yeah, no evidence is no evidence is no evidence is the way I would word it. But your motion to strike ends up being kind of like a semi-summary judgment. And so you have to meet the standard in order to get to get the RTP stricken or to get the RTP on the line if it went to the jury charge either.
So is this something that a lay person would know? You don't push a stretcher into somebody's back?
I would agree with you 100%, Justice Busby, except for I went up on mandamus to the Tyler Court of Appeals in this exact case, and I said this is not a healthcare liability claim because I don't need expert testimony. I can tell you what a layperson does. And the Tyler Court of Appeals told me, no, this is a healthcare liability claim because you do have to have expert testimony on that. And so then we went back and the Court of Appeals said the trial court had to dismiss Wolverton and East Texas, EMS. And so they were dismissed. But I would agree with you, but right now, that Tyler Court of Appeals is the law of the case. Justice Huddle, you had a In re USAA case that you decided when you were on the Houston Court of Appeals, and you indicated that a mandamus proceeding can create law of the case, even though it's not an appeal. And so I think that's the law of the case. And even if it weren't, it's completely unfair that we've been told you have to have, you can't bring it against them because it's a healthcare liability claim. And now they're using that affidavit to show the responsible third party. Now,
Has all this been decided yet in this case? Has any court ruled on the sufficiency of the evidence in response to the motion to strike in this case?
This was one of the grounds presented to the trial court. I think the Court of Appeals bypassed this issue and jumped straight to, we've already decided this in King 1. But it was before the trial court and is a ground on which the trial court made its decision.
And so on appeal, they would have to show that no ground supports the
Exactly.
decision. But should we send it back for the CA to address their complaint on the evidence sufficient?
I think this would be an easy opinion for you to write without having to send it back. I mean, it's just, you can look at the expert report. I think you can remand it to the CA, but I don't think there would be any reason why for you to do it. And you can evaluate Mr. Hawkins' expert report for yourself to see that it's insufficient. Now, I will tell you that relators are going to come up here and say that we have waived this argument. That is incorrect. It's a complete misunderstanding of how RTP practice works in our trial courts. They suggest that because we did not object within 15 days of the objection, that we were unable to file a motion to strike, but that's not how Chapter 33 works. So initially, they designate their RTP, and you can object within 15 days, but that is a pleading standard. Did they plead it? And the judge doesn't look at the merits, they don't look at the evidence, they take the pleadings as they are, and if it's supported by the pleadings, they must be designated. If they aren't supported by the pleadings, you need to give them another shot to redo their pleadings, and then it's designated. But then separately from that, that's 33004F. But if you look at that might be L. I think that might be L. And then if you look at 33004F, then there's a separate proceeding for you to do a motion to strike after adequate time for discovery. And there's no deadline on that. The standard is no evidence, as I mentioned before, similar to a summary judgment motion. So that allows you to procedurally strike designations later outside of the 15 days of that. It's kind of a two-part procedure there under the RTF. So.
Now, I think they've also pointed to, in addition to, you were about to tell us why Hawkins' testimony wasn't enough, and I'd like to hear your thoughts about that, but they also point to the testimony of Dunn and her coworker that Wolverton was negligent and deviated from the proper standard of care, and testimony from Dunn's doctor and surgeon and biomedical engineering expert regarding causation. So can you address all of those and say why they're not
Sure. Well, I
enough?
don't think Dunn, or there's another nurse who was another eyewitness. I mean, if we take Tyler for what it said to us, is you have to have expert testimony on.
Why can't a nurse be an expert?
Because she's not an EMS.
So she could be an expert, but not in this specific field.
Exactly. And
But
Hawkins.
would you have to be an EMS? I think we've said that if you can show by experience and training, you're knowledgeable about the appropriate standard of care, that's sufficient.
But either Dunn, and I think her name was Chenault, but I might be getting the other nurse's name wrong. Neither of them I opine about the actual standard of care in this setting, under these circumstances.
Did they say I'm familiar with what
No.
EMS people are required to do or anything
No,
like
nor
that?
are they designated as an expert.
And all of this is what the CA never addressed.
They never addressed it.
Okay, so that's done and her coworker, and you were about to tell us about Hawkins.
Yeah, so all Hawkins says is he goes through the facts. I mean, it's I don't know, I have it here, it's 6 pages or whatever. But he says, his conclusion is, and so he just recitates the facts. So he gives no more or less meaning than Dunn and Chenault. And if I'm getting her name wrong, I apologize to Nurse Chenault. But he gives no more meaning. And then he just says, in my opinion, and to a reasonable degree of administrative certainty, ETMC is responsible for the negligence, but he never states why there is, what the standard of care and how it was breached.
And what about the doctor and the surgeon and the biomedical
think they
engineering
were-
expert?
I apologize, Your Honor, I did not look at their testimony specifically.
I think it may be about causation.
I think
rather
it's
than
about
breach,
causation
but-
and not breach in duty.
If the court were inclined only to reach the issue of whether the RTP statute can be applied at all because it's a workers' comp case, my sense is that we would write an opinion, or we could write an opinion addressing that issue, but then we would deny mandamus relief no matter what that opinion says, because we'd have to allow the rest of it to go back down and be addressed.
If you want to do that, you can. I think you could write an opinion that says we're not going to reach it. I know King did that, King 2 did that. But you can say we're not going to reach the bigger issue because here, even if the statute were to apply, relators did not meet the burden in getting, the trial court did not abuse its discretion in striking the RTP designation because of the insufficiency of the evidence presented.
If we went that route, either way, it would be denying mandamus relief, even though like one path on that tree is actually an opinion that favors them?
Yes, I think so. But I want to, turning to the bigger question, because I know y'all don't take cases to talk about whether RTPs were, but I do think that's a very important point that I think might have gotten a little bit lost in the briefing. But to start on whether Chapter 33 should apply in a case against a non-subscriber for an on-the-job injury, I want to start with some principles that I think we all can agree on, because I think as questions have come up at this court, this isn't a model of clarity of how to interpret Chapter 3 together with Chapter 406. And so the principles that I think we can agree on is that the workers' compensation exists as a compromise between employees and employers for the on-the-job injuries. Secondly, I think we can agree on that the act is intended to incentivize being a subscriber. We want more employers to be subscribers. It's the whole act is to create incentives for you to subscribe to the system. And to that end, the Workers' Compensation Act penalizes non-subscribers. It is a penalty. This court has said it's a penalty going all the way back to the first 1913 workers' compensation statute. It is meant to be a penalty. If you want to non-subscribe, do so at your own risk, because there's benefits to the whole state when you are a subscriber and you have an on-the-job injury, and we've reached this compromise about we're not gonna, you're strictly liable, you just need to pay these benefits, you don't risk any kind of runaway jury verdict, it's just, and so that was the compromise. And so therefore, anytime you're looking at this, the risk should be on the employer who elected not to subscribe, not to the employee who had no say in whether her employer was a subscriber or not.
But when we look at the disincentive under 406.033, it says and that's the section that says you can't consider the employee's contributory negligence, et cetera. It says this section does not reinstate or otherwise affect the availability of defenses at common law. And was third-party practice available at common law even when 406033 was enacted?
Do you know what section of 406 that is? I'm sorry. I
Yeah,
know what one.
it's 406033B.
Oh, yes, okay. Gosh, in this week, I've researched what that meant, and I'm sorry. I will follow up with you on what that meant. But I do think that this, the overarching thing it had a specific meaning, and it related to an amendment that I think was like the 1937 amendment or something. Like, there was a meaning of why that was put in there, and I'm sorry, Judge, that I can't remember right now off the top of my head. But the way I look at this, 406033, is that it really tells you, here's what you won't have a defense of, here's what you will have a defense of, and it's meant to be, this is it, this is these are your defense. And I'm gonna categorize this because y'all have said that sometimes you can have a statutory defense, okay? But I think when you're talking about fault-related defenses, I read 406033 to be exclusive. It lays out, these are your fault defenses you can't have, these are the fault defenses that you can have, and beyond that, you cannot have a fault defense.
Yeah, except that it only addresses fault on the part of the employee or a co-employee.
I know,
It doesn't seem to purport to address third-party fault and contribution in essence.
That's right. And if I'm going to answer that because there's a whole section, 417, chapter 417 is about third-party liability. And so if I can back up just a little bit, going back to 33, and then I'm going to put you back into 417, if you'll just give me a little bit of a leash here. Okay. I thought we could all agree, but apparently from the argument this morning, we cannot agree that a claim against a non-subscriber is under the Workers' Compensation Act. The best scenario I can give you, client walks into a plaintiff's lawyer's office, she says she was injured on the job. First thing that lawyer has to do is pull up the Workers' Compensation Act and say, okay, where do we go from here? Were they a subscriber, not a subscriber? It starts and ends with the worker. So everybody is under the Workers' Compensation. All employees are under the Workers' Compensation Act, whether they subscribe or not subscribe. They have obligations and duties and defenses and not defenses. It's all under the Workers' Compensation Act. So they are under the Workers' Compensation Act. So what relators would like you to do is focus on the word benefit, okay? But that's not the phrase. The phrase is workers' compensation benefit, okay? And I think of it as a phrase and not just the word benefit, workers' compensation benefit. And if you go to chapter 417, which talks about third-party liability, they allow an employee to seek damages from a third party and to pursue a claim for workers' compensation benefits under this chapter, subtitle, sorry. So there you see, and you see it actually throughout I'm just giving you the most relevant provision, but you see the phrase workers' compensation benefit. That does not mean the narrow reading that relators claim it means throughout the code, but this is the most direct location of it. And then B, if a benefit is claimed by, and it B basically says that a subscribing employer can step into the shoes of the employee and seek claims, reimbursement, subrogation, whatever. So that necessarily, if a benefit is claimed, that has to mean against a third party, right?
It could mean if the employee claimed a benefit from their employer, then the employer gets to step into the shoes of the employee and sue the third party for subrogation.
And I thought about it, and I'm not a workers' compensation lawyer,
Well,
and
I'm not either,
I
but-
appreciate that none of you probably are, but the way I think about when you have, and I don't even understand, that's why I don't understand what that phrase before Chapter 33 really means, because typically what happens if I'm employed by a subscriber, and I have a claim, I'm going to assert my claim, right? And then if my employer thinks I'm not entitled to that claim for whatever reason, I have to go to the Workers' Compensation Commission, right? I have this exclusive remedy. I have to go to the agency first. And then we do this arbitration, and then if we disagree, we go to a contested case hearing, and then if we don't like the decision of the contested case, then we go to the review board. And then if we don't like the review board, then we get judicial review. But in no scenario, and there can be fact issues that people disagree about. Were you in the scope?
You're almost out of time, so.
I'm sorry.
So, yeah, there can be fact issues.
Yeah, there can be fact
Guess
issues,
where
but
you're going
but they're
with
not
this.
negligence related. I can't
Right.
imagine how that would be
And then
negligent.
meanwhile, you also have claims against third parties for the
Yes.
same injuries. You agree with Relator's counsel that you, that the employee who's injured pursues the exclusive remedy against a subscribing employer, and then also can sue the third parties, but the employer may have a subrogation right against those third parties.
But importantly, 417 lays out a separate proportionate responsibility about what the subscribing employer can get in a third-party action. And Judge, I hope you'll hear me out. They cannot take away Ms. Dunn's basic rights. If this were a subscriber, they would not be able, they can only reduce it by so much so that she still gets her basic statutory rights. And what
Sure.
they're advocating for
benefits.
is that Ms. Dunn would be better off.
So let me ask you this, the question I asked him, just simply, I hate to cut you off because you're being helpful, but the questions I asked about the try, settle, or dismiss scenarios against a non-subscriber, right? We got the non-subscriber. Obviously there's a disagreement about what happens on the dismiss side of that three-legged stool. What about the try and settle? Do you agree with him that if it's tried or if it's settled, that the result is the way Relator's counsel says it is?
I don't, and I'm going to stand by my position that Chapter 33 does not apply, and I also want to point that 417 makes sure that in
So
these.
what do you do if you had filed an expert report here and you had these claims against both the Relator and the EMT's employer, and you went to trial, how do we decide what your client's entitled to?
It's a tough, when you asked it, I was like, don't ask me the hard questions, Justice Boyd. No,
Well, his answer's pretty simple.
no, but the thing I want you to think about though is whatever happens, it can't be that Dunn, because she has a non-subscribing employer, cannot receive less than she would have if her employer were a subscriber, because then you contort the principles that we talked about that
No,
everybody
that
agrees
happens all
on.
the time, that you sue a non-subscriber and you get a defense verdict.
But that is what the.
Or the jury says, no, your damages are only $500.
But 417, I mean, 406 and 417 are meant to not let that happen. We do
I'm
not
gonna
want.
go look at that real carefully.
Okay,
Any
Thank
further
you.
questions?
thank you.
Thank you, Ms. Hobbs. Mr. Walsh, you have 5 minutes.
There's a lot to cover. Let me see if I can start at the very end here. 417 is about you can't take away their benefits under the workers' comp situation because that's a compromise. And that's why the third-party recovery of the employer is designed to be that compromise, is because they're getting limited benefits under the compromise. 417 doesn't apply to the non-subscriber because it's not part of the compromise. And so the way that is going to work is it's not under 417. And back to the scenario where we talked about either with you, Justice Boyd, or it was my suggestion, whether it's 40, 40, 10, or 20, or 45, 45, 10, right? I'm only paying my percentage share, which is no less than what my percentage share should be under that scenario. It's always that percentage share. And so it's not reducing what I owe her under any scenario. The reason it matters in this case is because they didn't get an expert report against the responsible parties. And I shouldn't be strictly liable to pay for their fault. If I have a little tiny bit of fault, I shouldn't have to pay for what they did wrong.
So she spent more than half of her time on the evidentiary thing Can you address that very quickly?
Very, very clearly. No court has actually addressed the evidentiary sufficiency, and this goes back to read the
Can you
transcript.
not presume the trial court did because that was one of the grounds?
It's generically in the order that the motion to strike is granted, or whatever it says, but the trial transcript says it had no discussion about that, and they only discussed, am I not bound by King 1 or not, right? And that's where they're stuck. Second, you're omitting the Wolverton's testimony where he said, look, I didn't do this, but if I did, I would have been distracted, and that would have been negligent. That's some evidence from an EMS. And the second thing is, as Justice Bland pointed out, multiple medical specialties could provide expert testimony in a situation, right? And so while he's not an EMT, who knows how to walk through ERs?
So it sounds like maybe if we do agree with you, we grant mandamus and clarify that you are entitled to RTP in a non-subscriber case, but without prejudice to the trial court's ability to now consider the evidentiary question.
And that's, exactly, and that's my quibble with Justice Blacklock, or Chief Justice Blacklock, where you said you just deny mandamus relief, and I think that's incorrect. If you agree with us on the Chapter 33, 406 part, right, you've got to grant mandamus relief because that's what the Court of Appeals did. You can remand to them to consider the evidence, or you can remand to the trial court to consider the evidence, but that's not denial of mandamus relief. The only way you deny mandamus relief is if you disagree with us on the Chapter 33, 406 issues, or you disagree with us on the evidentiary issue, or both. But if you agree with us on one or both of those, you would be granting mandamus relief.
Well, except that you're asking for mandamus relief undoing the district court's action, and if we haven't reached enough of the issues to know for sure whether the district court is wrong, then don't we deny relief despite having ruled for you on one of those issues and then send the other issues back to the Court of Appeals?
But you would be actually granting mandamus relief against the Court of Appeals, who's the one that got the law wrong.
So here's what we do. We deny mandamus without prejudice to your ability to put on an evidentiary record in the trial court to avoid the strike.
We'll accept that. And I could go through in a lot more detail about the evidence about how the nurses said they were walking too fast, they were distracted, they were either carefree or careless, and said that they were negligent. And all we're talking about is walking through an ER, right? And they talked about how you could hit a patient if you were doing what they were doing, and that they warned them.
Walking through an ER carrying a stretcher. That's a little different than just walking through an ER.
Yeah, but if you're walking through an ER, distracted, not paying attention, have a cell phone out, as they're accused of, as Wolverton is accused of doing, right? You're just as easily to walk into a patient or a patient's family member or some other staff member, which is why Nurse Chenault, which is the correct name, she said the correct name, said, don't do that. You're going to take one of us out.
At the risk of getting pedantic, the respondent in your brief is the trial court, not the Court of Appeals.
I accept. Any other question? I know that's his line. I only want to be helpful, so.
Any further questions? Thank you, Mr. Walsh. The case is submitted, and the court will take another brief recess.
Thank you.
All rise.